Some criminals think that they're above everyone else, but in the courtroom, it's the judges who have the final say in whether they walk away free or spend their entire lives in prison. From threats against officials,
that's 90 more. That's 180. That's 306.
Working at McDonald's,
to mocking the victim's family.
I just want to tell y'all I'll be home soon, or I'll be Keon. I love my family.
These are 10 times judges had zero tolerance for disrespect. Starting with what might be one of the most bizarre reactions a defendant has had. See, back in October of 2016, Jermarius Ellison, Del Reno Gacy, and Danto Wright were arrested for their involvement in the murder of 18-year-old Jordan Klee in Ann Arbor, Michigan. According to reports, all three teens were charged with murder, robbery, conspiracy to commit larceny, and felony firearm. Following multiple hearings, Wright ended up pleading guilty to the murder as part of the terms for his plea deal. It was a tragedy that deeply scarred the small community of Ann Arbor, so everyone was tuned in for his final sentencing as the prosecutor listed the charges.
On the morning of October 4th, 2016, did you agree and conspire with two other individuals, Del Reno Gracie and Jermarius Ellison, to commit an armed robbery?
Yeah.
But Wright didn't seem too worried about his impending fate. What made the situation even more disturbing was the way Wright reacted to the victim's family, reading a heartbreaking letter to the judge.
why you thought his death was an acceptable response to your jealousy or desire to what he had. Drugs, clothes, money, jewelry, phones, shoes, whatever it was that you felt you needed more than his life.
As he kept smiling and rubbing his hands to show everyone he wasn't sorry for what he had done. To make matters worse, he mocked the family directly by saying he would walk away from it.
I just want to tell y'all I'll be home soon, or I'll be Keon. I love my family.
But the judge cut Wright's celebration short by delivering a very real threat.
You know, I have never in 23 years approximately ever not accepted a sentence agreement between the parties because it's bargained for, sentenced by the parties, but watching you sit there, smile and laugh and shake your head like this was no big deal, I'm very tempted to just say, I'm not going to accept this sentence agreement. We'll go to trial, and if you're convicted of felony murder, you'll go to prison for the rest of your life. That means you'll die there.
He wasn't in the mood to smile anymore, as the prosecutor walked away to discuss the possibility of him spending the rest of his life in prison. Following this, he received a sentence of 25 to 52 years for second-degree murder, giving him a lot of time to smile while locked up. Now, it should be obvious that talking back to a judge is not the brightest idea. And this woman is the perfect example of how bad things can get if you do. Back in August of 2013, 32-year-old Ebony Burks from Elyria, Ohio, attended her bond hearing while facing misdemeanor charges for assault and domestic violence over a physical altercation she had with her uncle.
And/or 6 months in jail. Domestic violence is also a misdemeanor 1 and carries a possible fine of $1,000 and/or 6 months in jail. You have 3 pleas available to you today: guilty, not guilty, and no contest. You also have the right to a lawyer, and if you can't afford a lawyer, the court can appoint one for you. What plea would you enter?
Not guilty.
Court will accept your plea of not guilty. I'm going to assign your case to one of the courtrooms.
It seemed like a regular hearing until the judge set a no-contact rule between Burks and her uncle, leading her to continuously questioning the decision.
All right, Ms. Burks, on the domestic violence, I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact with Cedric McRae. On the assault, I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact with Tiffany Castro. No contact means you can't call him, you can't write him, you can't text him, you can't email him, can't leave a message on some social media, you can't go visit him. If you go someplace and either Mr. McRae or Ms. Castro's there, you have to leave. If you're someplace, even though you may have arrived first and one of them shows up, you still have to leave.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with...
Whoa, I'm talking. I don't need you to say nothing.
If you live with Mr. McRae, you cannot return to that residence.
Oh, but how you just gonna tell me I can't go home?
From there, she kept challenging the judge's decision, and it didn't take long before he multiplied her contempt sentence tenfold.
What?
How you gonna tell me I can't go to my house?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you've got 30 days. So you're not going... You're not... What? Get back! Get back!
You just said I got
Get back!
I'm not getting nothing else.
That's another 30 days. That's 60 days.
So what?
90 days.
So?
120 days.
Okay, and?
180 days.
Move!
Please, quiet.
Get off me! Get your hands off me, man.
Come on.
What else you got to say?
Oh, nothing. We'll talk in 6 months when you're ready to come back for your case.
Sorry, Your Honor.
Not as sorry as she's gonna be.
I ain't bad. They got commissary. I got money.
That's 200 days. You got anything else to say, Miss Burks? That's 300 days.
The judge later told a local newspaper that it was the longest sentence he had ever imposed for contempt of court, although Burks ended up only serving 88 of those days. As for this next man, it was exactly his inability to keep his mouth shut that landed him in court. In 2017, Florida native Alan McCarty Jr. let out his frustration at the Daytona Beach court judge following a lost custody battle.
Vacations were Hearst.
Yeah, I want to report a crime that's about to happen.
What do you mean a crime that's about to happen?
Yeah, there's about to be a crime that's going to happen if my kids don't come back to me, you stupid because your stupid judges don't want to bring people to courtrooms. I got a gun pointed at your building.
Sir, what is going on?
Who the you calling, sir, you stupid Where's your judge warrant at? You going to bring that out in handcuffs and I'm going to execute that son of a right in the street. I'm letting you know I'm going to shoot this. You gonna give me my kids?
Where are you at, sir?
I just told you I'm outside of her building waiting for her to get there in the morning. I'm gonna pop a cap in that you stupid.
It didn't take long for officials to identify McCarty and bring him to justice, with multiple charges for armed threats and extortion as a result of his stunt. It was also reported that the judge he threatened wasn't the one responsible for the decision, and that McCarty didn't have custody to begin with. When it was time for his initial hearing, he immediately let the judge know he would not be cooperating with any part of the trial process.
He's under oath from the start of the trial.
No, I'm not. I'm not under oath.
All right, raise your right hand. I'm going to swear you in.
I'm not under oath.
As his behavior kept getting more and more aggressive, the judge had no other option than to have him escorted out of the room to be able to proceed with the testimony.
My daddy owns the building and I look like a idiot, huh? Brought your dress today, you little prick. You wanna take my kids from me and act like that? You and that bitch. You loud with me? Is that what you're gonna do?
No.
Well then do it again. Come on. Shut the up. I'm trying to think over here.
Other room. It's done. Yes, sir. Alan, we're going to direct that through.
Motherfucker, take all my paperwork so I can't show these people? You want to take all my paperwork from me? Lock me in a cell naked all night?
Despite not being present, he still had a lot to say about the judge.
He can watch and hear what we're doing, and I'm going to allow him to confer with his attorney at the critical moments. But he's chosen to absent himself in the courtroom, just so you know. I've talked to him, if that's what you want to call a conversation, thus far. But you are not to perceive anything negative about that. He has a voluntary right to be here, which he's been given. And he has a voluntary right not to be here, which he's chosen to exercise. You're to perceive nothing of that.
McCarty would be found guilty on all charges and returned to the courtroom a month later for sentencing, only to take things to a whole other level and get dragged out as a result.
Here before the court, Mr. McCarty, to show cause why I should not hold you in contempt for behavior that you demonstrated during the jury trial. Number one, you threatened the unborn child of the prosecutor directly in an open
What a
court.
bunch of guys, you stupid piece of
Then also
You threatened my life, you
in the
you
back room.
suck my dick. No, I'm not standing. Not resisting. I'm not resisting. I'm just not stand up. I'm not standing. I don't have to stand. I hope you fall on that baby's head, you stupid. Never threatened that bitch. Bring play back the shit, you stupid mother. Yeah, keep looking at me, boy.
If getting 20 years in prison for the initial charges wasn't already enough, he ended up getting 10 extra days in jail following his disrespectful outburst. Now, just because you claim that the law doesn't apply to you, doesn't mean the judge is going to tolerate any disrespect. Henry T. Eldon, a sovereign citizen from Kanawha County, West Virginia, disobeyed every command given by the acting judge while he faced several charges for filing false claims against the court, all while having a friend act as a witness and mediator while he remained silent.
I'm a witness today of this. Okay. I'm a witness, okay? Okay, what I'm saying is, he is present, and he's chosen not to step up there. He's asking not for an appointed lawyer. He doesn't need an attorney, okay? So I'm just a witness that he is present here, okay? And I will repeat that when the court reporter begins.
You're acting in the capacity
I'm
of
not
lawyer?
acting. I'm a witness. Just an American national.
You can see the judge was already running out of patience, and every challenge from the pair just kept pushing him over the edge.
Henry T. Eldon. I have called him thrice. I have no response. Get up here in this seat right now.
The court reporter has to be established before anything can proceed.
Well, okay. Well, get up in your seat now, and we will wait for that. We have some preliminary thing.
We're all waiting for the court reporter to be...
Do it now.
When Eldon finally stood up, it was only to keep obstructing the trial, so the judge taught him a lesson in manners before instructing the deputy to administer his final verdict.
Have a seat. You are disrupting the court. One, have a seat. You are disrupting the court. Two, have a seat, please.
I would like to speak to the court, and I have information to present.
This is disrupting a governmental process.
I have no idea what's going on here. I have never seen charges.
All right, Mr. Allen, can you stand up for me, please? Turn around and place your hands behind your back, if you would.
And who are you?
I'm a Deputy Sheriff.
M.A. Dolan.
Yes,
and have you a badge number?
I'm 97.
And do you have a warrant, signed warrant?
I do not have a warrant. I've just been made aware by the judge that he wants me to take you into custody for obstructing the judicial process, okay? So...
I don't know how I'm instructing.
Last warning.
You won't comply
Get in
with
the
what he's
seat
asking
and
you
we'll
to do.
proceed.
Okay?
But that was nothing compared to the reaction this next judge had when facing a disrespectful offender. On May 18th, 2013, Jackson County resident Kamea Gomet was arrested for the gruesome murder of 38-year-old Marcel Hill following a domestic dispute. During one of her final hearings, however, she seemed much less remorseful about her acts, going as far as to laugh and mock Hill's aunt as she read a letter to the judge.
Thank God for the special gift that you will receive today from the judge. Is that it? When I finish, I'll let you know. Oh, okay. Serious?
This was all the evidence the judge needed to know he was dealing with a cold-blooded killer, and didn't have to put up with any of her back-talking.
Get the duct tape.
I'll sit here and listen to the lies.
You know what? She's got a right to talk to the court after you murdered a relative of hers. And you're going to shut your mouth or I'm going to have some duct tape put on it.
Well, he attacked me.
We'll wait here for a moment till we can get her quiet.
He waited until Gomet finally kept quiet to lash out, and told her exactly what he thought about her and what she had done, since she would never be able to set foot outside of prison.
And you end up probably in some kind of domestic, ultimately hit him in the head so hard with a pan that you actually cave in the front of his skull, and then you stabbed him no less than 12 times. And you know what? I was the only one in the courtroom that knew what kind of knife that was. And it was a big old long fillet knife. Because I used it to fillet pike and muskie and salmon. And I'll tell you, you gutted him like a fish in that apartment too. You were relentless. You stabbed, you stabbed, you stabbed, you stabbed, you stabbed until he was dead. You didn't think he was an intruder. You know, maybe one stab wound, okay. Maybe that's self-defense. But you put in 11 more to make sure he was good and dead. So I hope, I agree with the family. I hope you die in prison as well. You know, and if this was a death penalty state, you'd be getting the chair. You have 42 days to appeal my sentence. Think I've legally erred anyway.
Whatever plan this next guy had to get a lesser sentence flew out the window as soon as he started speaking. 21-year-old Milton Watts from Berea, Ohio, appeared in the town's municipal court after a warrant for his arrest was issued following failure to appear on domestic violence charges. When people turn themselves in voluntarily, it usually means they're ready to cooperate, but Watts had no intention of making things easy.
You were supposed to be here last month. You did not appear. Why weren't you here?
I had work. My mom didn't show up. Somebody died in the family. There was no reason for me to be here.
Watts was confident he didn't need a lawyer to handle his situation, but every word out of his mouth kept draining the judge's patience.
Your attorney withdrew, so you'll have to hire an attorney?
I don't need an attorney.
You're a lawyer?
Nope.
It's clear he had absolutely no idea about the process or about basic manners at that.
You want to talk to me about a bond with me? What do you want to tell me?
About what?
Bond?
I don't really give a fuck, to be honest with you.
He also did not know about the judge's zero tolerance for disrespect and ended up paying for it immediately.
That's going to cost you 30 days in the county jail for contempt. Cuff him if you got the cuffs. Hold on. It's $5,000 cash surety bond, temporary, subject to the temporary protection order.
But that was just the beginning of his expletive barrage, and the judge acted accordingly.
That's 90 more. That's 180. That's 306.
Working at McDonald's?
The true victims were his family members, who had to witness Watts throw his life away as they helplessly tried to lighten the charges.
Melvin, stop.
How many days you want to give me now? Are you sure counting?
Melvin,
Yeah, I'm at about a year right now in contempt, so.
He's got mental problems. He's not on medication.
Ma'am, I don't care.
I don't give a you.
Melvin, stop.
Everybody. You.
Melvin,
Power.
Good.
Power.
Good.
Suck daddy dick.
The deputy had to bring multiple security guards as backup to contain the situation while he calmed down. Despite initially facing 360 days for contempt, Watts was only sentenced to 90 days in jail, plus 5 more days for the initial charges. This next judge, on the other hand, had no one to stop her from dealing with a disrespectful felon. Defendant Anthony Mendoza attended Jefferson County's 252nd District Court to discuss the terms of his current probation for a DWI he had received 6 years prior. The reason behind it was that he violated several of the terms of his probation, including substance abuse and an assault charge, leading to his immediate arrest.
Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years. All right, Mr. Parker, you may proceed.
Well, a couple of things I want to address. It's a situation I see quite a bit where he's ordered to have to scram and interlock. It's costing $600 a month, and he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and he's not able to work, and he can't afford to pay for the things he needs to do, such as the 12-step program, the GD program, all those things.
Despite his lawyer's best efforts to get on the judge's good side, she wouldn't cut Mendoza any slack for being a repeat offender and showing no interest in complying with the law.
So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
But what really ticked her off was when Mendoza began blaming the system for his own mistakes, so she had to administer harsher treatment.
Okay.
I've actually done well through the program, through with the supervised supervision. The only time I messed up is when they stopped supervising me and made me go do these things by myself.
Well, I mean, how old are you? How old are you?
I'm 43.
43 years old.
And I have no felonies on my record except for this.
That doesn't mean anything. You have this felony and you have 6 years hanging over your head. And you've been given all the tools. You went to safety. You got aftercare. At some point, you have to take those tools and do for yourself and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking.
He could have stayed quiet, but it seems like he wanted to go down fighting. Sadly for him, it was the judge who had the final say.
Tools.
If I can
We're done. At this, we're done. No, we're done. Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to 6 years in the institutional division of the Texas Department of Corrections.
But it's not only defendants who can get in trouble for being disrespectful to judges in court. Back in June of 2011, American nationalist Bo Davis and other members of Keene's anti-government community were attending a trial for one of its members. Davis caught the attention of the judge for wearing a hat inside the courtroom, so he said one of the bailiffs to administer a warning for the violation, but he wouldn't make things so easy.
Take the hat off or step outside.
Define.
That's what I was looking for, was the definition of disrespect.
Now, there are many people who consider it disrespectful not to wear a hat under certain circumstances. Jews, for example, and Muslims are required to wear a hat in church, so this may be his way of showing respect, not disrespect. Who knows?
As the entire group kept obstructing, the bailiff's patience quickly began to run out, and he had no other choice than to give Davis a seemingly simple choice.
I think you misunderstood. It's the judge's authority when he comes back. If at that point he says he's in contempt, then you have the authority.
It would not have been an issue had you...
Your choice is take the hat off. I'm trying to be as nice as I can. I can't be nice. You'd be really nice if you were to not be.
After a few moments of back and forth, the bailiff ended up choosing for him and carried him out of the courtroom with the help of another bailiff.
Come on, stand up, please.
Sir, treat others as you would wish to be.
Please. I'm being nice. Well, I'm not going to assist in my own arrest. So
I don't. You should take your hands off that man.
At least stand up. All right, you want to stand?
You said you weren't wearing these forms.
All righty.
You seem peaceful. Why are you harming them?
Just light in the eye.
I got a slap in the face.
How much do you get paid to do that?
How long were you sitting here with the hat on?
I was sitting here for, I don't know, 20 minutes and not bothering anybody.
You guys don't treat others as you would wish to.
All right.
And that's
It's true. It seems like a clear
stand up.
Let's go.
Shortly after being wheeled away, the judge sentenced Davis to 5 days in jail for contempt of court. If only things could have been resolved by, I don't know, taking his hat off? Depending on the charges, bond hearings can be the shortest and easiest part of the judicial process, but this man decided to make it hell for himself. Michael Ray from Louisville, Kentucky was already facing some serious charges, including trespassing, assault, and making terrorist threats. Now, this next footage might look ancient, but bear with me, it's worth it. In 2017, Joshua Martinez from Nevada decided to represent himself in court while facing charges for driving with a suspended license back in April of 2017.
Good afternoon.
Hello.
On the charge of having a suspended driver's license on April 12th, what is your plea, sir?
I have a couple questions before we proceed. I don't understand the nature and cause of the charges.
You're charged with driving on a suspended, canceled, or revoked driver's license.
Despite the straightforwardness of the case, Martinez chose to obstruct the flow of the trial by continuing to ask questions about every element involved.
Is there a sworn statement against me or injured party?
I believe you probably received a citation on April 12th. That would be the criminal complaint filed against you.
Okay, and is there a injured party or damage to property here against me?
It's charge brought by the city of Las Vegas, sir.
Okay, so the city's the victim in the case?
The city is the, yes,
Victim?
the charging party.
So they're the victim.
It didn't take long for the judge to notice he wanted to take over the trial, so she reminded him who was in charge and sent him on a short vacation to give him time to think.
If the city if they are the victim, I would like to move this to a federal court.
You're gonna stop
No, we are in charge of the courtroom, ma'am.
Marshall, would you show Mr. Martinez the inside of our holding tank, please? You're not gonna tell me who's in charge of my courtroom, Mr. Martinez. Go ahead and go with the marshal. That is direct contempt of court.
When Martinez was brought back in the courtroom for his sentencing, the judge offered him a chance to make things right and apologize for his disrespectful behavior, but ultimately chose to take the high road instead. A little bit of respect could have saved all 10 people in this video a lot of trouble. But hey, at least they get to be famous for their poor judgment. If you want to see more videos discussing real court moments, hit that subscribe button and be on the lookout for what we have in store for you.